Finally, we get to selection. And selection is the third part of the hiring process. Selection often involves the use of, here, let me start all over. Finally, we get to selection. Selection is the third part of the hiring process. And when we talk about selection, we're often talking about testing. And pre-employment testing carries a lot of risk. Now, pre-employment testing, having to take some sort of test, has become pretty standard in the selection process. Once we've identified our job candidates, oftentimes we will have those candidates take a test. It's the standard now. We want to select the best possible candidate. Obviously, the best thing would be to do is to hire them and give them a 2-week trial. Let's see if you can do the job. You got 2 weeks. Yeah, that would work. That would show us whether this is a good candidate or not. But that's very expensive and very time consuming. And so to shortcut that process, employers often give tests. And the issue, again, testing is fine. Testing is not illegal. But what you want to be sure is, does the test accurately test for the characteristics that are sought? Does the test measure the abilities of the person that is taking the test? Will a person who scores high on the test do well as an employee? So this is the most important question when it comes to testing. Is the test do what it was designed to do, which is to provide the best possible candidate? Now, testing in the workplace takes two forms. There's testing for eligibility, and that's things like general mental ability test, personality test, integrity test, those who are best suited for the job. And then the other is ineligibility. These are disqualifying factors. Pretty much everyone now has had to take a drug test at some point in their life. That's a test for ineligibility. You cannot do the job because you failed the drug test. We'll start with eligibility testing. Now, obviously, there are Title VII implications to giving a test. Why? Because of those rules against disparate impact. If the test has a disproportionate impact, the employer can be liable. So when you decide to give a test, you need to be very careful as to what is the outcome of this test. We know that certain tests may have a disparate impact upon members of a protected class. And then, of course, we have an additional problem, which we'll talk about when we discuss Ricci versus DiStefano, that case, that sometimes employers can be so concerned about disparate impact that, in fact, their concern manifests as disparate treatment, meaning I treat people differently on purpose because I am so concerned about treating them differently by accident. And again, that'll make a lot more sense when we talk about Ricci versus DiStefano. And I'm going to do a special presentation on that because it's a very important test, but I want to focus right now on the rules regarding eligibility testing. We know that if a test has been professionally developed and validated, Title VII does not prohibit its use. That means that if I am going to give a test, if the test is developed by professionals and has been validated, and I used to have a lot of information on how validation occurs, but essentially validation establishes that the test accurately measures the characteristics that you're seeking to prove. We know that in order to give this test, we must establish that it's a business necessity and that it is predictive of job performance, meaning people who do well on the test do well on the job. I have to give a test that measures for this particular aspect, and I have to establish that that aspect will predict good job performance. So there's sort of these two aspects of testing involved. Now, even where these two requirements have been satisfied, however, the test may still be challenged if a less discriminatory alternative exists. Meaning, even if I can prove that my test is a business necessity, and if I can prove that those who do well on the test do well on the job, I also have to be concerned that there is a less discriminatory alternative. That's how you overcome the rebuttal of the prima facie case by the defendant. Now, there are other forms of eligibility testing. Integrity and personality testing have become more predominant. We have learned that integrity testing, combined with a general mental ability test, those are the top two predictors of job performance. Somewhat is a bit startling that, in fact, these two are better predictors of job performance than experience or our attitude or any of the other things that we think are predictive of job performance. Even past job performance is not as good a predictor of job performance as general mental ability test and integrity test. And so we've seen a number of employers adopt these integrity tests. Physical ability test. We talked about this a bit when we talked about disability, but physical ability tests are something that we can administer to applicants if there's a necessity for those physical abilities on job performance. If I'm hiring people to load trucks, and that will necessarily involve being able to lift 50 pounds packages, well then I can give a test to determine, can you lift a 50-pound package? So we can administer physical ability test. We can administer tests designed to test your stress ability, that how you perform under stress. Many employers require pre-employment post-offer medical test. This is when you can give a medical test. You made an offer, a conditional job offer, made conditional on the basis of passing the test. So many employers can require those physical tests, those medical tests, after making the offer. Now, testing for ineligibility can also cause problems. Why would an employer want to test for ineligibility? Well, you want to find someone who can do the job. You don't want them to be disqualified from doing the job because of some other factor. And of course, we may want to prevent workplace injury. We want to make sure that these people are not going to injure at the job or that they're going to injure someone else. And those are really the basis for most drug tests. We want to use these tests to predict employee performance. And if I give a drug test and it comes back negative, I can say that people who don't pass the drug test are worse employees. And therefore, testing for ineligibility is possible. Testing can also reduce the employer's financial responsibility to the workers' compensation system. The way workers' comp works is that the employer is required to essentially pay insurance, because workers' comp is what we call a strict liability statute, meaning you get hurt on the job, then you get paid. You don't get paid as much as you would if you brought a negligence case, but you get paid automatically, whether it was your fault or not. Well, the only reason that works is that employers have to contribute to the workers' compensation fund. And therefore, if I can give a test that's going to reduce the chance of workplace injury, then that's going to ultimately reduce my obligations to the workers' comp fund. Testing ordinarily is legal. Under most circumstances, employers may test applicants. Privacy issues are only involved when there is a public employer, like the government, and not a private employer. There's no constitutional right of privacy involved with the private employer testing. If I am, drug testing, clearly that's an invasive search. That's a search of your body, whether it's your hair follicles or your urine. That's a very invasive search, and maybe that would not be permissible for a government employer, but it is permissible for a private employer. So on your test, look for those situations. If it's a public employer, there may be privacy concerns. If it's a private employer, probably not. Now, there are state statutes that involve private sector requirements for workplace testing, and all I can say is make sure you know your state laws as to the requirements for workplace testing. And of course, remember too, the common law still applies. If we decide to give drug tests and you're concerned that someone's going to fraudulently provide someone else's urine, and you decide, well, I'm going to make everyone stand in a room and pee at the same time, well, that's probably going to lead to a common law claim of invasion of privacy. So private sector testing, remember, is still subject to the common law. The common law is always acting out there at the same time. The tort system, it's not employment law, but it's acting in conjunction with employment law. Workers can claim reckless or negligent infliction of emotional distress based on testing. So keep those things in mind. And in fact, again, an employee can have a claim for defamation arising out of a failed drug test. If someone fails a test and then you go tell everyone, you failed the test, if it's not true, that may have defamed this person. That may have cost this person the ability to find another job. So an employee may have a claim for defamation as well. There are other problems with eligibility testing, and we haven't really talked about polygraphs yet, lie detectors. Polygraph testing is illegal for most purposes. The Employee Polygraph Protection Act of 1986 provided that polygraphs are not permissible unless they are specifically targeted. So once upon a time, it was very common for employers to require employees or prospective employees to take a lie detector test. Well, lie detector tests are notoriously unreliable. That's why they're not admissible in court. And therefore, in 1986, Congress passed a law that says essentially employers can't use lie detector tests unless it's for very limited purposes. If I have a situation where I own a jewelry store and there's jewelry missing, I can't simply say, look, everybody's going to take a lie detector test. Everyone's going to take a lie detector test, all my employees. I can, however, narrow it down to 2 employees and say one of you must have done it, therefore I'm going to give you a lie detector test. As an attorney, I would tell you, just don't mess with them. Don't do it. The government uses lie detector tests because they're exempt from the statute prohibiting the use of the lie detector test. But no one else does, and it's not a good idea. Drug and alcohol tests, we said, those are routinely given. Everyone has taken that at some point in their life. Now, I mentioned the idea of the public employer, and the public employer can change the analysis, even for a drug test. This case involved Border Patrol employees who worked down at the U.S.-Mexico border back in the 1980s. And for the first time, the government started requiring those employees to take a drug test. It would be no problem if it was a private employer, but because it's a public employer, then it raises potential issues according to the Constitution. The Constitution says government cannot invade your privacy, cannot engage in a warrantless search. And that's what a drug test is a search of your body. So the Border Patrol agents acting through their union brought a claim saying we can't be mandated to take these tests, not these random tests that are unrelated to any investigation. In that case, the court, however, said that this test is actually pretty narrowly determined only for those people who might be influenced by drug users or drug dealers who are bringing drugs into the country, and therefore is justifiable. So drug and alcohol tests, even for government employees, are pretty routinely granted. The next area to watch is really genetic testing. And in fact, the government has already stepped in with an act called the Genetic Information Non-Discrimination Act, which prevents an employer from acting on any information that comes out of genetic tests. So be sure to be careful about that. So in conclusion, what did we learn? Recruitment of employees is regulated by both statutes and the common law. There are multiple legal issues related to information gathering and selection, and testing is the third part of the hiring process. And that's it. Thanks.